public meetings on matters requiring approval under the Planning Act. During the meeting, there will be an opportunity for questions and answers from committee and the public. Before we begin, members of the public are advised that if a person or public body does not make oral submission at the public meeting or make written submission to the Corporation of the Municipality of Central Elgin before the decision, the person or public body is not entitled to appeal the decision of the Council of the Corporation of the Municipality of Central Elgin to the Ontario Land Tribunal. Further, if a person or public body does not make oral submission at the public meeting or make written submission to the Corporation of the Municipality of Central Elgin before the decision, the person or public body may not be added as a party to the hearing of an appeal before the Ontario Land Tribunal unless, in the opinion of the tribunal, there are reasonable grounds to do so. Those wanting to be notified of council's decision on any application should email Diane Wilson at dwilson@centralelgin.org, indicating which meeting they wish to be notified on and providing their name and address. Those who do not have access to a computer and wish to be notified should call Diane Wilson at 519-631-4860, extension 286, and provide the same information. We'll call this meeting to order. This is a public hearing as required by the Planning Act to hear the applicant Donald, Matthew, and Linda Gilbert, and every other person who desires to be heard in favor of or against the application for a minor variance from the zoning bylaw respecting 559 West Edith Cavell Boulevard. Does any member of the committee have a disclosure of interest concerning this application? I'm seeing none. If the applicant or agent is listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you have called into the meeting using a telephone, please dial *9. We will acknowledge your raised hand and you can unmute to explain the application. Yes. Sorry, I have the wrong glasses on. That's Mr. Gilbert on.
Yes.
Mr. Gilbert, you can go ahead, please, and explain the reason for your application.
Sure, yeah. Can you hear me?
Yep, we can hear you perfect. Thank you.
Excellent. So yeah, the purpose for the minor variance is the cottage at 559 West Edith Cavell Boulevard in Port Stanley is in a designation area with residential dynamic beach, natural hazard, regulatory flood uprush, and modified regulatory uprush. As a result, there is a floodplain that goes up significantly above the ground level. So what we are seeking is to build a 3-story structure in zoning for 2-story while respecting the 2-story maximum height restrictions, where the first floor will really just be a garage for storage, non-livable space, in order to get above the floodplain and still build a single family dwelling.
Thank you. What method of notice and when was notice given to the public of the hearing?
Madam Chair, as per requirements of the Planning Act, notice was mailed by regular post to every owner of land within 60 meters of the subject land and applicable agencies on April the 8th. Notice was physically posted to the property by municipal staff as well as the municipal website, and notice was displayed in the weekly CE Buzz advertisements.
Thank you. Mr. McClure, do you have any comments or questions with regards to the application?
Thank you, Madam Chair. Nothing further to the report.
Thank you. Are there any comments by municipal staff on the application? Seeing none. Have you received any written submission on the application, Mrs. Wilson?
Madam Chair, correspondence has been received from Kettle Creek Conservation Authority stating KCCA regulatory requirements have already been satisfied by the application for the proposed reconstruction on the existing foundation, KCCA permit number P21031.
Thank you. Do members of the committee have any questions on the application? Councillor Rowe?
Thank you. Not really a question, more just a comment. So we've had some planning applications in that area further to the east, I guess, for 3-story houses. I would just ask anyone that's building in any area within Port Stanley to be respectful of their neighbors. I'm just concerned the 3 stories will block the people that are up at the top of the hill. So if there's any way to just kind of watch where that peak of the roof ends, because the one that's on the further to the east is a monstrosity.
Do you have any further comment, Mr. Gilbert?
Yeah, we're staying underneath the 2-story zoning maximum height. And behind our property, there is a significant hill that goes, at least 30 to 50 feet above where the top of our cottage reconstruction will terminate. So no one up our hill with cottages or any view concerns will be in any way, shape, or form blocked.
Okay, very good. Thank you.
Thank you. And Councillor Fairhead. First, go ahead.
Just a question to, I believe, possibly Lloyd. For the encroachment, if they don't build the foundation within their boundaries, do we have to go through the encroachment bylaw to deal with that?
The foundation or the proposed structure is our staff's understanding that it's going to be utilizing the existing foundation or a portion of it. So right now, the existing foundation is encroaching onto the Iola Street road allowance. So the applicant would be required to enter into a licensing agreement similar to what we have on other situations to allow it to remain in its current location.
Councillor Kravitz.
So my question was going to be the same. Seeing that the existing building is going to be taken down, and by the looks of what I can read into it, the only thing that's being saved is the foundation. Would now not be a good time to contain the building within the property limits? I don't know what the issue is, why you're saving that piece of foundation and having to encroach onto the road. Just seeing this, I think now would be the ideal time to move it onto the property line. Is there any thought that was put into that?
Mr. Gilbert?
Yeah, so we're actually keeping the first floor of the structure and then reinforcing it with helical piers and then going up. So maintaining the exact same foundation in first floor.
Councillor Kravitz?
Sure.
Okay, thank you, Mr. Gilbert. Any other questions from the committee? No, seeing none. Is there any members of the public, Mr. Perrin, who are on? No? Okay.
No raised hands.
No raised hands. I'll go through the spiel. If you are listening on your computer, and this is for the public, if you're listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you have called into the meeting using a telephone, please dial *9. The questions will be taken in a sequential order. When given the opportunity to speak, please provide your name and address for the record. Is that?
There's Madam Chair, there's an individual on the phone dialing in from 519-579 are the first digits. You state your name.
Can you please
Yes, thank you. My name is Leslie McDonald, Dean, and we have the property at 534 Upper Spring Street. And first off, I'm a little dissatisfied with your system. You provided some Zoom instructions online, but with no password. So I'm not able to get in, nor is my cousin. And we were hoping to actually appear in person via Zoom. So just so you know, some of your information is not accurate on your website. But having said that, let me go through my comments with you. So we are the cottage on the other side of Iola Street, and we own right down to the other side of the private lane. And so the biggest concern we have is with respect to the third story and where that's going to be in relation to the hill, and whether or not it's going to obstruct the view of both, in my case, ourselves, and of course I'm speaking on ourselves, but I know our cousin is immediately behind it, and I know that's a concern he will be expressing as well. And I'm going to direct you to the committee, to the report, the CEP 1522 that was prepared by Steve Craig, the senior planning technician, wherein Mr. Craig acknowledged in his review of the four-part test for minor variances, and more specifically noted in section 4 entitled minor in nature, that in determining whether it's minor in nature, and I quote, "It has much to do with the potential impacts of the proposed development on the subject lands and neighboring properties." He then went on to say that aside from the expansion of the third story for this legal non-conforming property, no further reductions to the zoning bylaw are proposed. Therefore, no new adverse impacts are anticipated. What this statement fails to take into account is whether or not the increase in height as a result of the proposed expansion negatively impacts the adjacent property owners. And I believe someone has already spoken to that and maybe asked questions earlier. I was just having some difficulty hearing it on my phone. And unfortunately, unless I'm missing something, one can't tell from the reference plan that was attached to the application where the top of the new roof will be in conjunction with the top of bank immediately behind the subject lands. I know Mr. Gilbert commented that he thought it was a really high distance, but we need somebody's expertise and perhaps the surveyor's expertise to identify exactly where that top of bank is from the sort of base of the existing cottage. As a long-standing property owner in Port Stanley, we do not wish to see our view of the lake compromised by an additional story, including the roof, and nor should it impact the view from our aunt's estate, which is immediately adjacent at 532 Upper Spring Street. I would suggest to the committee that perhaps the better alternative is that the committee secure additional information to determine the top of bank behind the subject lands and compare this to the height of the proposed development before you render your decision. And if there is no obstruction, then would suggest the committee impose a condition specifically speaking to the maximum height allowed for the new development. And I think Mr. Gilbert offered comment at the beginning that in fact, this particular property is only supposed to have 2 stories, and they're suggesting that the first story, which is the storage and what is proposed parking, should not count as a story. And I would argue with the committee that perhaps that's wrong. The reality is you've got 2 stories now. It doesn't matter what the use is of those 2 stories. It is already 2 stories. So if that's truly the case, then the committee really shouldn't be looking at expanding that, in my opinion. I would also note with interest that the drawings show the second and third floor will be cantilevered over the foundation at both the front and back of the house. This is beyond the foundation and exceeds the expectation that they will build on the foundation, which is a requirement of permission for a legal non-conforming property. I also would note in the comments there is discussion about access to the property being over a right-of-way, which would cross over the portion of the right-of-way on our property, which does not contain a structure at the moment, but it's a vacant sort of land at the bottom, or which we use in the summertime. So because we don't have any kind of structure there in the wintertime, we don't need access to it. So we don't do any kind of plowing or maintenance of that laneway for the purposes of accessing our property during the winter, and nor should there be any expectation at any time that we contribute it to snow removal. So I'm not sure how they get access to the property. In terms of the comment regarding the side stairs being removed from Iola Street, we are fully in favor of that requirement. But in addition, with respect to the encroachment of a portion of the current foundation, and I know there's some questions asked by some of the members, I would suggest to you that this is the perfect time to have the foundation altered so that they can build within the lot limit. So the application and what was circulated to the public implies that the whole building was being reconstructed from start to finish. And so if it's not, then I think the application should be adjourned so people can review this further. Because it's my understanding from reading the material that we got late last week was that this was a complete rebuild. And further, I would finally ask that requesting the municipality post no parking signs on Iola Street as that and enforce the same, because we recognize that parking is intended to be under the deck and in the garage. However, people have a tendency to go to the open area for parking, and this has been an issue in the past. And with that extended deck, I suspect it's going to be a little more awkward for people to park directly on their property, and it's not fair for the users of Iola Street accessing the beach to have to walk around cars that are parked where they shouldn't be. So those are really my comments that I wanted to share with the committee today. And as I said, I'm a little frustrated with your system that I couldn't do this by Zoom, because I prefer to see people's faces when I'm speaking. But thank you for your indulgence and giving me the opportunity to speak.
Thank you. Actually, Mr. McClure, do you have any comments with regards to her first concerns regarding the height?
Thank you, Madam Chair. As part of the discussion that was maintained, I guess, when we had a consultation with the applicant, I guess a few months ago now, part of that comes down to the definition in the bylaw of how it's determined to be a story, what's considered to be a story. So if it is unenclosed at that garage level, then that would not be considered a story within the bylaw. Ultimately, though, what my understanding is from Mr. Craig's report is that the ultimate height that has been provided or through this application process would be consistent with single detached residential dwellings that have been approved in the past. Ultimately, as was provided by the applicant, the lower level is not really habitable space, and that's really one of the I guess the provisions and then the bylaw to deal with the height in stories within the bylaw itself. Again, through that process, with respect to the view issues, it wasn't raised as a concern through the application, and nor was it addressed through Mr. Craig's application. He does note that the third story was I guess the only change in the overall zoning bylaw permissions. I guess currently that there are already encroachments, so there aren't asking for any other encroachments that don't exist today. However, as he indicated, that third story is the only piece, and from his analysis and review, he felt that it was minor in nature. With respect to the access concerns, that was one of the pieces that through his conditions, he wanted to make sure that there was a formal written legal opinion from the applicant that he is able to obtain legal and secure access from a public street to the subject lands. That West Edith Cavell, and I think Mr. Perrin can speak more to this, is not an open road allowance. So while there, I guess historically has been access along that kind of unopened road, that was one of the conditions that Mr. Craig wanted to have as part of this, just to deal with those concerns, some of those concerns that were raised as well.
Mr. Perrin, did you want to add?
With respect to the access to the property, the travel portion of the easement that extends west of Bartholomew is actually all in private ownership, and properties have easement over their neighbor's property for right of access. That's the basis of that requirement in Mr. Craig's report.
Thank you. No, okay. Councillor Fair?
Just in regards to what the lady was talking about, I noticed Mr. McClure, are you saying that if a floor is, like say the bottom floor, if it was opened and not enclosed, it's not a story? And yet when you're explaining, you said the third story a number of times. So it does appear that it's 3 stories, not 2 stories.
Mr. McClure?
Thank you. I think it's, sorry, if I could, I mean, if I put the bylaw itself, ultimately, if there's less than 50% of the, Floria, again, I can't off the top of my head, essentially, if it's unenclosed, it's not considered a story. For the purposes of, I guess ease of explaining, the second story, which appears to be a third story on the drawing, would technically be classified as a second story within the bylaw. So, and I know it's confusing, the way that the bylaw is worded and the definitions for story. That was part of the explanation and some of the discussion with the applicant at the time of the meeting, was to try to have it unenclosed in order to deal with it not being considered a quote unquote story. However, as again, it goes back to Mr. Craig's report that he's explaining it as a third story as per the definition. He's satisfied that the request is minor in nature based on the 4 tests. And he was satisfied that this is something that could be supported or should be supported by the committee based on his analysis.
Thank you. Mayor Martin?
Yeah, when I look at the diagram of the building itself, I would say that the first story, the lowest one, is enclosed. You can see on 3 sides, it's solidly enclosed. If the diagram is accurate, and the south side, it appears to be doors or windows, but both the 3 sides are definitely solidly enclosed.
And if I may, so ultimately, the way that it is, regardless if it's a story or not a story, the height of the overall structure is within what has been permitted previously in similar types of designations. Ultimately, the way it goes through this, the application process, was that the main level, I guess, where the garage is, they're going up in order to accommodate parking on the property away from that traveled portion of that kind of easement, as Mr. Perrin had indicated, and to allow for similar living space on above where the existing kind of main floor is or would be. Again, so it goes back to if it's 3 stories, as shown in the diagram, if it's enclosed or if it was not enclosed, ultimately the height of the building itself is consistent with the heights of other buildings and structures that have been approved along the stretch of West Edith Cavell.
Thank you, Mr. McClure. Deputy Mayor Marks, I'm sorry.
Thank you. I can vivid memory of the late Mayor Sylvia Hoff's. One of the reasons that compelled her to run for council was because where they were living in Port Stanley, someone built in front of her and took away her view. Sadly, she found out that the planning, if someone can build it, there's no guarantee of protecting your view. Is that true, Mr. McClure? Because irregardless of that, 3 stories, 2 stories, in the future, someone, fills it in and it is a full story. I think what you're saying is the height, as long as it's under a certain foot, that's what it is. So
that is correct.
2 stories or 3 stories?
That would be correct. There's no guarantee for view. If somebody owns property in front of your property and they decide to build within the confines of the zone, then they could potentially be obstructing your view.
Thank you, Mr. McClure. Is there any more questions? Councillor Rowe.
Thank you. We've talked about before for other buildings, the distance of the foundation to the bottom of a slope. So I don't know exactly where this foundation is in relation to the slope that's at the back, but is it in the right place? Given the distance that's typically required, or is this grandfathered in?
I guess to that comment, Kettle Creek Conservation Authority is the authority that would look at those, I guess, developments within or adjacent to hazardous lands. As my understanding from the comments that were provided by Ms. Wilson earlier on, is that they were satisfied that they were able to meet the requirements. Permits have been either obtained or well advanced to deal with the development and reconstruction of those helical piers. And that was, again, one of the requirements as part of the conditions by Mr. Craig's application, that the appropriate geotechnical work be completed to deal with the development within or adjacent to a hazard, and that Kettle Creek Conservation Authority sign off on all, and the applicant obtain all the necessary permits to allow for the development in this location. So I believe that they have satisfied Kettle Creek, or at least well advanced in the process with Kettle Creek to address those concerns.
Go ahead.
That last question, again, I think Councillor Kravitz asked it before, but it's still not clear to me. Staff had mentioned that there were 3 options to consider for the easement for the encroachment. Which of the 3 is being considered, and is removing the existing porch the solution? Because I'm sort of the same mindset that now is the time to fix the foundation on the property line.
Mr. Perrin.
The porch will be removed. That's encroaching onto the Iola Street road allowance. With respect to recognition of the existing encroachment of the existing foundation on the Iola, we would recommend that a licensing agreement be executed between the property owner and the municipality to allow it to remain there, subject to certain conditions imposed through that license agreement, such as notification of the municipality if there's any work to be done, as well as liability insurance, naming the municipality as additional insured.
Thank you. Councillor Kravitz.
So I see this was submitted 3 weeks ago, this application. So before the building permit is issued for this building, I'm just wondering the process here. Like before the building permit is issued, do they have a demolition permit? And in that demolition permit, is the foundation removed, or is it going to be removed when it's demolished?
Mr. Perrin.
So first of all, building permit cannot be issued unless an application satisfies all applicable law. So either zoning would be one of those. In this case, a minor variance would have to be required to support a building permit application. And as stated by the applicant, the existing ground floor level that's there now will be utilized, as well as the single floor living space that will just be reinforced with the next story going on top of what's there. So there'll be no demolition other than the roof that's coming off.
Thank you.
Just curious about the process. Thank you.
Any further questions? And we don't have, oh, sorry. We have another somebody from the public.
Go ahead.
Mrs. McDonald?
No, this is actually Sean Dean.
Okay, and your address?
So the 536A Upper Spring Street.
Thank you. Go ahead.
Same thing as my cousin had mentioned. I'm having a problem with getting in on your portal. My only concern that I had was the height. Was it going to exceed the height of the hill when standing at the top of where I look down? And there was nothing in the drawings as to say what the height of the new structure totally would be and what the height of the top of the hill is. The other thing I had a concern about was, the same thing which I think you have discussed, which is the encroachment on the roadway, Iola Street, with the foundation. And was the footing at the back of the property with the correct offset for allowance? And does it cantaloupe over further than what the existing footprint is.
Mr. McClure?
With respect to the, I guess, the building specifics, I'm not too sure if Mr. Gilbert wanted to speak to that, as has been kind of discussed throughout this this process. Ultimately, the foundation itself is to be used, and I can essentially beefed up to deal with the added height of the proposal. So I believe what I'm gathering from the discussion from the applicant is that ultimately, as they're going up and the main floor is to I guess be utilized as part of that existing structure, that kind of overhang is, or cantilever, already exists. But I could confirm that with the applicant could speak to that.
Mr. Gilbert, are you still with us?
Second.
Hi, can you hear us now?
Yes, we can. Go ahead.
Yeah, my apologies. Yeah, so the plan does call for a cantilever. It's 2 feet to the south and 2 feet to the north. And again, utilizing the existing foundation and first floor structure.
Thank you. Mr. Dean, did you have anything further?
No, I didn't have anything else other than, as I said, my main concern was what the elevation was, and unless I missed it in your drawings, because I didn't get notification till Friday to really look over them, that was there anything in there showing the height versus the height of the hill? I did see it shows where the top of the hill is, but it didn't show the elevation. Other than that, I didn't have any other concerns.
Mr. McClure, just for information's sake, we did state earlier that you can't really protect your view, but is there anything you can add as to the elevation, how it relates to the hill behind?
Thank you, Madam Chair. I don't have any other information as to how the height relates of the proposed building relates to the hillside behind, other than is my understanding that the hill is quite a bit higher than what the height or the roof peak would be of this current structure, or the proposed structure, sorry.
Okay, thank you, Mr. McClure. Mr. Gilbert, were you wanting to add?
Now, I was just going to say, we do have the geotechnical report, which will be submitted along with the legal opinion regarding access. I'm just looking at the diagram now, and it's 6 meters. So I think that's approximately 18 feet to the toe of the slope. And then it goes back another 20 meters, so 60 feet, and another 10 plus meters to the top of the slope for their evaluation. I can't comment specifically on the height from the top of the stairs where Mr. Dean is located. However, I can assure everybody that our plans are less than the maximum zoning allowance for a 2-story structure, and our intent is not to build a monstrosity and obstruct anyone's view or enjoyment of their property.
Thank you, Mr. Gilbert. Is there any other questions from the public? No. Councillor Krebitz.
Just one clarification on the front and rear side, the setback. With the cantilever, does that change in the application or not? I'm just curious.
Mr. McClure? Mr. McClure, are you able to speak to it? we still there?
Yeah, Ms. McClure, my question was the front and rear setbacks for the application, including the cantilever. Does that change the application? I was just curious if I could have that information, please.
No, so again, that goes back to that this is, I guess, an existing situation in which ultimately through the minor variance process, they're essentially allowing or requesting for a minor change to what is currently on there. So no, what the cantilever, all of that information would have been taken into account through Mr. Craig's review. And again, from his report and recommendations, the only, I guess, the only increase was that stories. And in order to satisfy what was being proposed, those number of conditions would need to be addressed by the applicant. So from his perspective in his review, the only deficiency or change to the zoning was that additional height by what's being proposed through the drawings that were submitted with the application.
Thank you, Mr. McClure. Again, any other questions from the public? No, seeing none, and any further questions from the committee? No. So everyone has been given a fair opportunity to be heard. Is the committee ready to make a decision? Yes. Yes, no?
We have to.
Okay. Actually, are we able to, you have to call the vote, or are we able to? All those in favor?
Madam Chair, my understanding is Councillor Cook is unable, she's having difficulty.
We're working through it, so
Right.
right now you can go ahead and do the vote by show of hands.
Okay. All those in favor of the application? Opposed? Aye.
I wonder if we could defer this for the next thing so that we could find out information about height and et cetera, some of the questions that were asked.
It's 3-2.
No, it was 3-3.
3.
To you, Madam Chair, procedurally, the motion was put before council and voted on and deemed a tie. A tie is deemed to be a failed vote.
A failed vote?
Yes.
So application has not been granted. And so to Mr. Gilbert then, he has to go back to planning.
We've gone against staff.
Or I guess it's too late for the deferral.
I think through Madam Chair, first thing you need to do is announce the results of the vote to formalize that
Okay.
the motion is defeated.
So for those who are listening, the motion was defeated because it was a tie. So procedurally, if there is a tie, then the motion is defeated. So that means the application is not granted. And next steps. Go ahead, Mrs. Wilson.
Madam Chair, notice of decision would be circulated tomorrow.
Okay.
By mail, and then Mr. Gilbert could make a decision on how he wanted to proceed with that deferral if he was wanting to appeal it to the Ontario Land Tribunal.
With that decision.
Correct.
Not
That's the existing, the decision
Okay.
as it is, as defeated tonight.
Okay. Mr. Gilbert, did you just hear the explanation? Do we still have them on?
Yeah.
Hello?
Hello, can you hear us?
Hello, Mr. Gilbert?
Can you hear
Yes.
us?
Okay, yes, we can hear you. So, so you had heard the explanation how the motion had been defeated.
Yeah, I'm confused by the verdict. Is the reason for the 3 no's based on height?
I have no idea to that. It was a tie vote. And a tie means a defeat. A tie defeats the motion. So that means that the application will not be granted as presented. And so a notice of the motion is going to be mailed out tomorrow, which you will receive. And then your next steps will be how you want to proceed after that, whether you want to appeal the decision of the committee through the Ontario Land Tribunal.
Was there an issue with a 7th member not being able to vote?
There's 6 of us here at the meeting tonight, and so we all have our opportunity to vote, and it was a split vote.
Mrs. Nguyen, somebody mentioned that maybe we should defer the vote because they didn't understand the height. We're going below the height allowance on our build, correct? So I don't know if that was clear to everybody. Everybody kept asking the same question on the height. We're not exceeding any of the height property. So someone had that question and then you went straight to the vote. So I don't understand what happened there.
Okay, one moment.
Madam Chair, procedurally, the vote was taken and the decision was rendered. Unfortunately, the decision is the decision and there can be no more discussion at this point.
So as I explained, you will receive in the mail the motion, the defeat, and then you have an opportunity to appeal the decision by the committee.
Okay, in this letter, is it can explain what the concerns were?
No, there won't be explanation on it. So the ball is then in your court as to whether you want to appeal the decision that was made this evening by the committee.
But if the committee doesn't understand.
And
Yeah.
Unfortunately, as was just stated, the decision has been made. So there's no more discussion on it. It means that once you receive the mailing, then the decision by you is how you want to proceed.
Okay, all right.
Okay. Thank you. And I guess we're on to the next application.
Adjourn. Adjourn that meeting.
Adjourn that one. Okay. So,
25.
all right. This meeting is adjourned. And we're going straight in. Okay. Sorry, Diane, was that? No, okay. Okay. So this is a public hearing as required by the Planning Act to hear the applicant, Kevin and Kelly Miller, and every other person who desires to be heard in favor of or against the application for a minor variance from the zoning law respecting 494 George Street. Do any members of the committee have disclosure of interest concerning this application? And I'm seeing none. If the applicant or agent is listening on your computer, tablet, or smartphone, please click the raise hand icon. And if you have called into the meeting using a telephone, please dial *9. We will acknowledge your raised hand and you can unmute to explain the application. Mr. and Mrs. Kelly, I see your hand is raised. If you can unmute, you can go ahead and explain the reason for your application, please.
Hi, can you hear us?
Yep, we can hear you very well. Thank you.
Thank you very much. So we live at 494 George Street. We have a front porch, which is starting to deteriorate. And we would like to replace the front porch using the existing footprint. Currently, the stairs head to the west of our property and then turn and head to the north of our property. As in the drawings that we have supplied, we would like to have those, basically have the porch the exact same size and have the steps continue on to the west side of the property, which I believe is the minor variance towards our neighbor's property line.
Thank you, Mr. Miller. Mrs. Wilson, what method of notice and when was notice given to the public of the hearing?
Madam Chair, as per requirements of the Planning Act, notice was mailed by regular post to every owner of land within 60 meters of the subject land and applicable agencies on April the 8th. Notice was physically posted to the property by municipal staff as well as the municipal website, and notice was displayed in the weekly city bus advertisements.
Thank you. Mr. McClure, do you have any comments with regards to the application?
Thank you, Madam Chair. Nothing further to the report.
Thank you. Are there any comments from municipal staff with regards to the application? I'm seeing none. Mrs. Wilson, have you received any written submissions on the application?
Madam Chair, correspondence has been received from Kettle Creek Conservation Authority stating no objections.
Thank you. Do members of the committee have any questions on the application? Seeing none. Mr. Perrin, do we have anybody from the public on?
No.
No. Thank you. Everybody's been given a fair opportunity to be heard. Is the committee ready to make a decision?
Yes.
All those in favor?
Karen Cook's on, so we do.
Oh, is Karen on now? Okay, Mrs. Wilson, can you take the vote, please?
Councillor Rowe.
Yes.
Councillor Kravitz.
Yes.
Councillor Cook. Councillor Cook.
Yes.
Councillor Fair.
Yes.
Councillor Wynn.
Yes.
Deputy Mayor Marks.
Yes.
Mayor Martin.
Yes.
Granted.
That application has been granted. Those wanting to be notified of the committee's decision on any application should email Diane Wilson at dwilson@centralcalton.org indicating which public meeting they wish to be notified on and provide their name and address. Those who do not have access to a computer and wish to be notified should call Diane Wilson at 519-631-4860, extension 286, and provide the same information.